Hi everyone. Today's video is very important and very timely, especially for families dealing with H4 and H4 EAD approvals. So over the past few months, I've been getting a lot of messages and comments about long delays, work authorization gaps, and travel issues and confusion around what is allowed and what is not. So there's a lot of mixed information out there, and instead of just guessing or speculating, I felt it is best to bring in a qualified immigration attorney to help us understand what's really happening and how people should think about this situation. So I'm very happy to welcome Gabriela from Manifest Law. Many of you already know Manifest Law. They are a US-based immigration law firm, and they work extensively with extraordinary ability visas, EB-1A, O-1, and H-1B families, H-4 dependents, EADs, and long-term immigration planning. Gabriela, thank you so much for joining us today. Before we jump into the questions, most of our audience already know you. So still for those who may have come here for first time, could you please briefly introduce yourself and tell our audience a little about your background and work you do at Manifest Law?
Sure. Well, thank you for having me today. My name is Gabriela Oriza, and I'm an immigration attorney at Manifest Law. I have almost a decade of experience. I have specialized throughout my career in business immigration, so work visas, and also working with some of the largest employers in the world.
So for everyone watching, just a quick note before we continue. If you have any immigration related needs regarding whether it's H-1B, H-4 EADs, green cards, employer filings, or long-term planning, I recommend check out Manifest Law. I've added that link in the video description, and you should able to see a QR code in the screen right now. So that should take you directly to them. As always, this conversation is meant to provide general information and clarity. Immigration rules can change and every case is different. So for your advice specific to your situation, it's always best to consult an immigration attorney directly. Let's get started with the questions.
Yes.
Okay, Gabriela, we keep hearing a lot of delays with H4 and H4 EAD approvals. From what you are seeing in real case, how common are these delays across US, and are people really waiting 8 months to a year? And what are the main reasons you think USCIS is making this delay right now?
Yes, so unfortunately, the delays are very real. We're hearing about cases that are taking even 10 months to get approved for H-4 and work permits. So it's very unfortunate. Some of the biggest reasons that we're seeing these delays are USCIS staffing shortages and internal backlogs. Also, H-4s and work permits are not priority categories for USCIS. They're focusing on, for example, marriage-based work permits, right? Also, with this administration, we have seen a heightened security checks, a lot of new policy manuals, just raising the scrutiny and the level of review that officers now have to do for the same applications. Also biometrics for categories that didn't require biometrics. So all of this creates a backlog, right? Also cases are getting separated internally, even if they're filed together. Historically, we understand that if we file the H-4 and the work permit together with the H-1B, it should be faster, right? And even if you go to USCIS website and you click on USCIS processing times, you select the type of category, they have two different categories. H-4s that are filed with the H-1B and H-4s that are filing without the H-1B. And they have significantly different processing times. So, even though the ones that are filed with the H-1B are taking longer than usually, they're still faster than filing the H-4 independently.
Okay, so that leads us to second questions. H-1B has premium processing, but H-4 and H-4 EAD don't. So many families file H-1B, H-4, and H-4 EADs together and upgrade the H-1B to premium processing. Does this still help in practice, or are the H-4 and EAD approvals still getting stuck?
So technically, the premium processing only applies to the H-1B, but the H-4 and the work permit tied to the H-4 cannot get approved unless the H-1B gets approved, right? That's most cases. So indirectly, think about it. If you are able to secure an approval faster for the H-1B, that indirectly helps the H-4 and the work permit to also have a faster adjudication. Now, in terms of H-1Bs, it is taking about 2 weeks to get an approval if you file with premium processing and they don't issue a request for evidence. Another thing, this is a practice pointer. for people, and obviously consult with an immigration attorney before attempting this. But something that I also did in my practice was for people that really needed their work permit and they were on H-4 status, what they did was file the H-1B first with premium processing, secure that approval, assuming the H-4 holder has a valid visa stamp and still valid underlying H-4 status, even if it's just for a few weeks or even a few months, travel, do a quick trip internationally, and then enter the US with a copy of the new approval, H-1B approval notice, and a copy of the marriage certificate, and then the admitting officer will issue you a new I-94 extending your H-4. So as soon as you come in, you file for the work permit extension and you include the new I-94. So that's a way to get that H-4 status faster and also be able to apply for an extension for the work permit faster than the traditional way.
Okay, but I mean, at this point of time, for Indian applicants, that may not be an option because, like, if you go out of India, I mean, if you go out of US, there's a huge backlog to secure an appointment in the consulate. So that option probably right now is ruled out for at least Indian audience. So that is one thing.
If they don't have a visa, right? If they don't have a visa, but there's some people that are Indian nationals that do have an H-4 visa stamp that's still valid. So that's a good strategy for them. Also, another strategy for people like you said that don't have a visa stamp is to do it internally, file for the H-1B together with the H-4 and the work permit, and then after the extension has been pending for more than 30 days with USCIS, file an expedited request for the work permit based on some of the criteria that USCIS allows for. And we can share the link. I created a manual step by step on how to do this. We can share a link of how to do that with your audience so that they can follow it. I've done it with some clients and it has gotten approved. The difference in not getting it approved is that people usually just file a generic, application to expedite their work permit. They don't write a letter that's very specific. They don't include the evidence. Like, for example, I filed one that was based on financial hardship. We made the argument that we needed both incomes to cover all of the expenses of the household. And of course, they made a chart delineating all of the expenses and also copies of the bills, like the lease, the rental, the electricity, the school for the kids, and then copies of the pay stubs to show that they need both incomes to cover the entire household. And it got approved.
Okay, that would be really good information. Thank you, Gravila. I'll link that in the video description. The next question is, like, say, like, the delay is more than like 240 days, because we know that, like, if someone applies for like H-1B in a premium, they would get an approval. But if the H-4 is pending beyond 240 days, they run a risk of going in out of status, right? So apart from exiting the country, do they have any other option they can try to get it here?
So the rule for the 240 days, it's very important that people pay attention because it's discretionary, but also it's important to understand how it works, right? So when you file for an H-1B extension prior to your H-1B expiring, if by the time your current status, H-1B, expires and you don't have that approval, and you haven't departed the country, then USCIS allows you up to 240 days to continue working and living in the US, assuming that you don't depart the US, that you stay grounded, and that you have at least 240 days left on your H-1B, right? Because sometimes people think that they can rely on the 240-day rule, and let's say they're maxing out of their H-1B in 4 months. So that they wouldn't qualify for the 240 days. They would be protected under the shorter amount of time, either whatever is left on their H-1B or the 240 days. If they run out of the 240 days, then they do have to depart the country. In that situation where they're like a month away from running out of the 240 days, it is recommended to file for premium processing to upgrade the petition, because if you're going to get an RFE, it is better to get the RFE now than in 6 months, especially if you don't have 6 months.
So What about the cases where the H-1B is approved? Like they applied for a premium processing, the H-1B is approved, but the H-4 is pending beyond 240 days. In that case, what options do you think that those candidates have?
Right. So generally, the person, if they file an H-4 extension prior to their expiration, generally they are protected. They can continue staying in the U.S. because it's not their fault that this is taking USCIS so long. Unfortunately, unless they have a valid work permit, they can continue working. But some of the options, like you said, is if check USCIS website to see the processing times for the H-4. If their petition is out of those processing times, then they're able to go to the USCIS website and file a out of processing times request. Or they can call USCIS and place an inquiry with a second tier officer. So that would get the case moving, especially if it's outside of processing times.
Okay, so let's talk about travel while an H-4 EAD is pending. If somebody travels outside the US and re-enters, their I-94 usually changes. Do they need to inform USCIS about the new I-94 with their pending application, or how does that work?
So generally, when someone has a pending application and they depart the U.S., it's very important they speak to an immigration attorney prior to doing that, because most petitions, especially extension of status, would be interrupted if someone travels outside of the country. If they have a pending work permit, generally people are required, or it's advisable for them to upgrade or update USCIS with the new I-94, so that USCIS is able to see that they have a new valid I-94, or even if their status got extended by way of re-entering the country.
Okay, that makes sense. So what happens if H-4 EAD expires while extension is still pending? And we know the person has to stop work immediately, but are there any legal options during this gap? Like, for example, unpaid leave, or they can volunteer, role change, or staying on payroll without working? What is allowed and what is not?
I'm very happy you asked that question, because there's a huge misunderstanding about volunteering or working for free. People think that because they're not getting paid, they're able to do this, and this is not the case. For people that have an H-4 work permit, once it expires, all work has to stop immediately. There is no grace period. There is no working quietly option. What is allowed? People are allowed to go on unpaid leave and to remain employed but inactive. So they cannot stay on payroll. They cannot help out formally. They also cannot do remote work in the US if they don't have a work permit. And very importantly, volunteering in a role that will normally require being paid is not allowed. To give you an example, if someone says, well, I can volunteer and serve as a consultant for free for this nonprofit, not allowed, because usually consultants are paid in this role. However, if someone says, well, I want to volunteer at a soup kitchen for homeless people, usually allowed, because people don't get paid doing this type of work.
Okay, and obviously that is not going to help keep their actual IT job there. Yeah, that makes sense. Okay, so at what point should someone take action for delays? So what is the reasonable amount of time you think somebody has to wait so that USCIS takes them seriously?
This totally depends on your type of request, your type of visa, your type of petition, and then the processing times of USCIS. So to give you an example, if you have filed an H-4 and work permit together with the H-1B, if you go to USCIS website, it is taking USCIS 5 months to adjudicate 85% of these petitions. If you then go and try to submit an inquiry request, but your case has only been pending for 4 months, the system will reject it. They will tell you your case is still within processing times. Try again when your case is out of processing times. So it won't even let you file a request. So you have to make sure first what type of case you have, and then what's the processing times that USCIS has right now for your case. And then if your case is out of processing times, then you're able to either submit an inquiry request online or call USCIS and speak to an officer. But prior to that, you're not really allowed to do anything else other than wait.
Okay, because I mean, like each center has a different wait time. Like I can see that Texas is a little faster, like in and around 5 months, but Vermont is like 8 to 9 months. So in this case, somebody has to wait at least 8 to 9 months, and then only they can apply for expedite request.
No, for expedited request is different from inquiry request. So inquiry request, asking what's up with your case, for example, it has to be outside of the processing times, right? However, the expedited request, I usually advise clients to wait at least 30 days after filing the petition just to make sure that USCIS has your petition on the record, and then you can submit an application for an expedited request with all of the documents, all of the evidence, and a good letter asking for your case to be expedited.
Okay, so 30 days should be like after filing 30 days, and then we can go ahead and raise for like expedite request. Okay, that makes sense. Yeah. And also, there is one other route. Like some people are reaching out to congressmen, like either their like House of Representative or their senators to expedite their request, because I believe they have a pathway to request USCIS to speed up or like do something. So, do you think that option is actually helpful, or like do you have any insight about that process?
Yes, I actually done it for some of my clients, and we had a situation where we were waiting for a B2 extension for like 7 months, and we hadn't heard anything back. We asked for an input from a congressman. They send USCIS an email with all the information of the client with a signed release form, because USCIS cannot just give this congressman or congresswoman information about your case unless you sign a release form. So make sure you sign that. We literally got an approval like 2 days after. So it's very, very important that if you have this option, to at least attempt it, right? Make sure you include all the information about your case, your USCIS receipt number, a copy of your receipt or receipt notice, and also the signed consent, the release signed consent before the congressperson goes in there and asks for an update.
Okay, so let's imagine a scenario, Gabriela. So a person has applied for H4 and H4 EAD. It's not approved for like now 2 months. So do we have to raise the expedite request first and then we go with the congressman, or is it like at what point you decide like, okay, this one can go with the expedite process and this one can go with the congressman?
The Congress input or help is done after you have used all of your resources, right? Like USCIS will not provide an answer or an update unless your case is outside of processing times. So the only option that you have to get an answer faster, if you're still within processing times, is just to file an emergency request for an expedited request for your case. Other than that, if you don't really have an emergency listed as one of the criteria for the expedited request, then you have to wait until the case is outside of processing times. Then the second step is to submit an inquiry request with USCIS. And then the third step is to use congressional help.
Okay, that makes sense. This question is little outside of this topic. So in India, there are like folks who are now reporting that they cannot see any visa appointment slot for 2026. Do we have any official information or like any insider information which attorneys received that says that like they've suspended or like for some reason it's like stopped until 2027, or is it like just we need to wait and watch for the official information?
So we don't have any official guidance from the government in terms of availability or why the applications are being pushed that far away. It's just more clients are reporting that there are no availability. And I don't think that they're pausing or shutting down availability. I think they're trying to restructure the capacity that they have to review all of these applications and visa appointments, especially because in light of the World Cup, right? I'm sure you saw that the government made an announcement that they will give priority to people who have a ticket from an official match from FIFA. Again, think about capacity in terms of embassies and consulates. If they're giving priority to these other visas, then their staff is even smaller. And then with the new social media vetting that has to do a deeper vetting for these profiles, they're just so limited with the amount of time that they have, that they're trying to restructure and organize themselves. I do anticipate that appointments are going to start opening up, especially for the second half of the year, but it's something that people have to keep an eye on.
Okay. So that's all the question I have. As always, thank you so much, Gabriela.
Of course. Thank you for having me. Have a good day.
Thank you so much.
No worries. Bye.